Webinar is now live.
Okay. Good morning, everyone, and welcome to Project Sentinel's 2021 Fair Housing Symposium panel on Fair Housing Protections for Families. My name is Daniel Williams, and I'm a Fair Housing staff attorney with Project Sentinel. I'm excited to introduce our two panelists this morning, Liza Crystal DeMann and Todd Espinoza, both of whom are very experienced fair housing attorneys. Liza Crystal DeMann is a partner at Brancart & Brancart, a Bay Area law firm that represents plaintiffs in housing discrimination cases in federal and state courts throughout the United States. She joined the firm in 1997 after graduating from Stanford Law School. Since then, she has successfully litigated hundreds of fair housing cases involving discrimination based on race, national origin, gender, including sexual harassment, sexual orientation, disability, and other protected characteristics. In 2014, she was lead trial counsel in a certified class action involving violations of California's residential security deposit statute. The jury found in favor of the class and awarded over $2.25 million in damages. Liza has been honored by the State of California Department of Fair Employment and Housing with their Civil Rights Hero Award and by local fair housing agencies throughout California. She is a frequent speaker at fair housing conferences, law schools, and state bar trainings, and she served as one of the contributing authors of the Rudder Group desk book entitled California Fair Housing and Public Accommodations. Todd Espinoza is an attorney who has practiced law in the Bay Area since 2000. He represented tenants as a staff attorney with the National Housing Law Project in Oakland. He represented consumers and investors in class action litigation at a private law firm in San Francisco. Todd also served as a deputy attorney general in the consumer law section of the California Department of Justice. Todd received his law degree from Harvard Law School, and he holds a master's degree from the UC Berkeley Department of City and Regional Planning. In 2020, Todd was elected as a member of the American Law Institute. Before we get started, I would like to remind everyone to please complete our very brief poll before you log out today, which you should be able to find towards the bottom of your screen. Also, please feel free to leave any questions you have in the chat box during the presentation, and we'll go ahead and address them at the end. With that said, I'll go ahead and turn the floor over to Liza and Todd.
Great, thanks very much. Let me just start the presentation. Okay, well, thanks very much for joining us, everyone. Really happy to have you all here during the last bit of these unusual times. Like Daniel said, I and Liza Crystal DeMann will be presenting on overview of familial status discrimination and state and federal fair housing laws. Just a quick disclaimer, just so everyone understands the nature of the presentation and our roles here. Both Liza and I are lawyers, we're attorneys, but this presentation is for informational purposes only. It's not tailored to anyone's particular circumstances, either tenant, housing provider, landlord, property manager, whatever. And it's most definitely not legal advice. That goes also for the question and answer session that we'll have at the end. We don't give legal advice in any kind of public forum. So just to be clear, information purposes only. We're lawyers, but we're not your lawyers, and this is not legal advice. So just a quick overview of what we're going to be talking about today. Like I said, it's a presentation on fair housing laws and familial status discrimination, state and federal. We'll give an overview of the federal and California laws regarding housing discrimination as they relate to familial status, and some discussion of what familial status means in the context of those laws. And then we'll also give some more detailed discussion of some particular issues and case examples, case type examples that tend to come up in regards to housing discrimination and discrimination against families with children, discrimination against children, discrimination based on age, that sort of thing. And then we'll do a conclusion followed by a question and answer session. So with that, I will turn things over to Liza for the next several slides.
Thanks, Todd, and thanks everybody for coming today. Thanks to Project Sentinel for hosting this symposium. I was just saying before we got on that these symposium have been going on for many years, and I've been attending them for many years. And every year, I personally learn something from attending Project Sentinel's annual symposiums. So you've all done yourselves a favor by signing up and attending, and we appreciate your attendance and look forward to learning from you and hearing from you at the end of the presentation. I want to start out by just giving you an overview of state and federal law as it applies to fair housing and specifically familial status discrimination. The general rule here that I want to tell you about is that if something violated the Fair Housing Act, the federal law, then it also violates California's Fair Employment and Housing Act. That is not true in reverse, not vice versa. In other words, California has more protections for renters and for tenants and for individuals and people searching for housing in general. More protected classes, and it covers additional properties that federal law doesn't cover. So California has a broader law than the Federal Fair Housing Act, but if something violates federal law when it comes to housing discrimination, it also violates the California Fair Employment and Housing Act. Next slide, please. The two main laws that we use when we're talking about housing discrimination under California law are the Fair Employment and Housing Act and the Unruh Civil Rights Act. Now, FEHA also covers employment as well as housing discrimination, obviously. So I would just encourage you that when you are looking at FEHA to make sure that you are not citing to an employment section of the act. For example, if you have an employment discrimination claim, typically there's a requirement that you have to file a complaint with the Department of Fair Employment and Housing before you can just run off to court and file your own civil action. That, in other words, you have to exhaust your administrative remedies. That's not true when it comes to housing discrimination. And so you have to be careful when you are using FEHA to make sure that you're actually looking at the housing sections of the law and not just the employment sections. There is no exhaustion remedy. You don't have to go to the Department of Fair Employment and Housing first if you have a housing discrimination complaint. The Unruh Civil Rights Act is broader than FEHA in that it actually covers all sorts of business establishments. It's not limited to housing. But Unruh does cover rental housing as a business establishment. It also covers all sorts of professional real estate and mortgage lenders and people like that. And it outlaws all sorts of discrimination that is considered to be arbitrary. The regulations that you see referenced on the right side of the slide, this is something that is relatively new in California. The Fair Employment and Housing Council has recently implemented new regulations under the Fair Employment and Housing Act, and they are really good and they are really important. They largely track the regulations that HUD has promulgated on the federal side, but in some cases they're even better. I would say particularly in areas of disability rights, the California regulations actually provide some additional protections that the federal regulations don't necessarily provide. So take a look at those at 2 Cal Code of Regulations 2005 and forward from there, when you have a chance to do that, or if you're looking specifically at some particular fact pattern, because those regulations are actually quite helpful. Next slide, please. So looking specifically now at federal law, the main federal law that outlaws discrimination in housing based on familial status is, of course, the Fair Housing Act. And it has a number of provisions which could apply in cases of familial status discrimination. Subsection A, so that would be 42 USC 3604A, generally outlaws excluding people based on their familial status, evicting people because of their familial status, or just otherwise making housing unavailable to families with children. Section 3604B pertains to discriminatory terms and conditions. In other words, we'll rent to families with children. We're just not going to treat them the same as everybody else once they move in. That's discriminatory terms and conditions. It can include other things as well, different terms in leases and things like that. But most frequently, we use that section when we're talking about discriminatory rules. Section 3604C of the Fair Housing Act prohibits discriminatory statements. So that's any statement that could be verbal, it could be oral, or it could be written that indicates to an ordinary person, an ordinary listener, an ordinary reader, that there is discrimination going on, or that there is a preference, or that there's an intent to make a preference or to discriminate. That statement violates the Fair Housing Act, even if it's motivated by goodwill, even if it's motivated by a desire to protect families with children or to protect children from harm. A statement that on its face conveys a limitation based on familial status violates the Fair Housing Act. That's a very important provision when it comes to discrimination against families with children in housing. The other sections that we sometimes would use in the familial status area, 3604D, which prohibits lies about the availability of housing based on familial status. So if an individual or a tester is told by a housing provider that no unit is available right now, even though in fact there is, and the reason the tester or individual has been told that is because they have kids, and the housing provider, for whatever reason, does not want to rent to a family with kids, that violates 3604D. And then the last provision that I want to specifically highlight for you under the federal law is Section 3617. This is the provision that prohibits any form of retaliation, coercion, intimidation, and threats, either because someone is exercising their rights as a family with kids enjoying their housing, or because somebody has participated as a witness or as a complainant in a discrimination complaint. That would violate Section 3617. On the right side of your screen, you see a citation to the regulations that HUD has promulgated that are taken into consideration by courts when they interpret the Fair Housing Act, and courts generally defer to those regulations when they're interpreting the law. That is really what I would consider the meat on the bones. So if the Federal Fair Housing Act is the bones, is the skeleton of what is outlawed, the federal regulations really put meat on those bones by giving lots of examples and lots of additional information about what types of discriminatory housing practices or what types of practices are considered discriminatory and that violate the Federal Fair Housing Act. take a look at those regs. If you have a case or if you have a complaint, that should be really one of the first places you go to if you're analyzing a fact pattern and trying to decide if it violates the Fair Housing Act. Next slide, please. I'm going to turn it back over to you now, Todd. I think this one's yours.
Thanks, Liza. So just a quick interlude here to make sure everyone understands and we're clear on our terms here. We've been using the term familial status, but we just want to make sure that everyone understands what that is. It's a defined term both under California law and under the federal law. Essentially, what it means is, like Liza was referencing, essentially it means referring to households or families with minor children, so children under the age of 18, mostly. But it also includes situations where children are on the way or in the process of joining the household. So familial status also includes a situation where a person is pregnant or where the household is in the process of obtaining custody of a minor child, either through adoption or through fostering. The other thing I'll say is all the housing discrimination laws also cover situations where a person or a household might be targeted for discrimination based on assumptions or beliefs or stereotypes about them. So refusing to rent to someone, for example, because you expect that household to have a child on the way soon or to be adopting a child shortly, is also discrimination that is unlawful under both state and federal law, even if it's a mistaken belief, even if the housing provider, the landlord, the property manager is wrong and the person is not intending to adopt or to include a child in the household. So just to recap, familial status more or less means presence of minor children in a household, children under the age of 18, but also includes situations involving pregnancy, adoption, and fostering. The one other statute that I'll highlight, in addition to the FEHA, the California State Fair Employment and Housing Act, and the Federal Fair Housing Act, is the California UNRU Act that Liza mentioned earlier. The reason I'll emphasize that in particular is that, as Liza said, it's very broad and it covers essentially all business establishments that even situations that otherwise wouldn't be covered under the other laws. And it's very important in the context of familial status discrimination in housing because it specifically addresses and prohibits discrimination based on age in housing. And those provisions in the statute and in the UNRU Act were added specifically to prohibit discrimination against families with children and children in rental housing in particular. The statute actually refers to cases that were decided, specifically adopting the reasoning of those cases that the UNRU Act prohibits discrimination against children in rental housing, but also just other forms of housing in general. We as plaintiff lawyers, well, I'll speak for myself, I particularly like to make use of the UNRU Act for a couple of reasons. One is that the coverage is very broad, so there's really no question that would come up in California because of the UNRU Act. If is this a situation where the child actually is a member of the household, or how far along is the person in the adoption process? It's going to be discrimination based on age because there's a minor child involved. And UNRU, the other thing I'll point to, it provides quite strong relief, powerful relief, as far as the remedies that a plaintiff, a victim of discrimination, would be entitled to receive under that act. There are minimum damages that are available under the statute, in addition to as much as triple damages that a person can recover in a situation where they can prove that they were discriminated against based on age or some other reason. So now's the portion of the presentation where we're going to start talking about some specific issues and examples that tend to come up with regard to housing discrimination and familial status discrimination. But actually, before I do that, there was something I just wanted to mention. There are, in addition to the state laws, the federal laws, the state regulations, and the federal regulations, there are some local ordinances that specifically address housing discrimination against families with children. In particular, off the top of my head, in the Bay Area, San Francisco actually has an ordinance on its books that's quite old. It dates from the 1970s, before the current federal law was amended to include discrimination based on familial status in housing that prohibits housing discrimination against families with children. And interestingly, it actually provides for criminal penalties. It's actually a misdemeanor in San Francisco to discriminate against families with children in housing. The statute actually provides for up to 6 months in county jail for an offense. I don't know if of a landlord ever actually doing time in county for familial status discrimination, but it's on the books. It's theoretically possible. But turning more now back to the house rules examples. So first one that we tend to see, one of the things that tends to come up a lot, one of the things that when you're looking at a situation where you think there might be some discrimination based on familial status, based on discrimination against families with children, we'll look at the leases, or at least I will as an attorney, and also the house rules that tend to be referenced in those leases. And it's really, even today, even though these restrictions against discrimination against families with children have been on the books for decades, it's still fairly common to see discriminatory rules and policies in writing and in black and white in people's leases, or in house rules or postings that tenants are required to follow. One of the most common, I would say, would be a requirement that children be supervised at all times on the premises. There's been a fair amount of litigation all throughout the country, but especially in California, challenging these types of rules. They're generally going to be unlawful. A blanket rule like that requiring a child to be supervised at all times is going to be a restriction on the terms and conditions of the family's tenancy, and that's going to be based on familial status, which is going to be illegal. And the statement itself is going to be a statement of discrimination, et cetera, that it's going to be independently actionable, even if it was never directly enforced. The other thing I'll emphasize, it's also going to be a discrimination based on terms and conditions, because often you'll see a provision in a lease that the tenant is responsible for complying with the house rules. So essentially, the tenant is being provided lease on worse terms than they would otherwise receive if they were a household that didn't have families with children. Because the point here is that this rule singles out children, and households who don't have children aren't required to supervise other people who might be in their household at all times. It's a direct facial discriminatory requirement that is targeted specifically at a member of a protected class, families with children. Other situations that do come up would be, say, restrictions on the types of areas or the types of units where dwelling units where families with children might be able to reside. So we don't rent second floor apartments to families with children, or we don't allow children to be in certain areas or to use certain portions of the facility. So examples would be, children may not play in the west courtyard. Facially discriminatory. You're specifically targeting children with that statement. Similarly, restricting areas only to adults. Upstairs patio, only adults can make use of that patio. Again, discrimination against children. You're excluding children from the upstairs patio. Violation both of state law and federal law in the ways that we described. Occasionally, you will also see, and I've actually run into it in my practice, discriminatory lease provisions. So the most direct example that I've seen, and it happened just a few years ago, so it's still going on. I had a landlord include a no pregnancy clause in a lease in writing, and that required the family to move out after a certain number of months if one of the tenants became pregnant and gave birth to a child. So this sort of thing still does happen, and it happens in an overt way that is surprising given how long on the books these requirements against discrimination against families with children have been in existence. And then the other thing I'll mention, and I think Liza touched on this, but I'll just emphasize this, discrimination based on familial status is essentially on the same level in the fair housing laws as any other form of discrimination. It is just as illegal to discriminate against families with children as it would be to discriminate against someone based on religion or race or ethnicity or color or gender or sex. There's not some lesser level of protection that applies, even though it's a newer within the statutes type of protection. So if you were to take out child or adult or under the age of 18 and specifically identify a person based on race, that wouldn't fly with regard to race or religion or disability or one of the other classifications. It's not going to fly with regard to familial status, and it's going to violate the various federal and state fair housing laws. And so with that, I will turn it back over to Liza.
Keep it on this slide for a second, if you would, Todd, because I just wanted to add a couple of observations before we move on to the next slide. I too, in my practice, see a pretty high number of complaints regarding discriminatory rules. And a couple of examples that I thought I would share with you, because I think these come up pretty often, are issues around pools. And there is a state health and safety code that says you can restrict unsupervised children under the age of 14, I believe it is, from a pool area. And so that is one age-based restriction that is specifically allowed under a different code. And so it wouldn't be unlawful under the Fair Employment and Housing Act or the UNRU Act to have that sort of rule around pools. On the other hand, if you restrict the pool at certain times by age, we've seen restrictions, for example, that children are only allowed to use the pool at certain times of the day, or that lap swimming is the only thing allowed during various times of the day when the times that most children are most likely to be out of school, like on the weekends, for example. That could be considered discriminatory. Same thing if you restrict the hours of play. I had a case a number of years ago where there was actually a playground at an apartment complex. And of course, apartment complexes aren't necessarily required to have a playground on site, but this particular one did. But they wanted to essentially discourage children from using it. And they did that by saying the playground is closed during the hours of 3 p.m. to dark, and it's closed on the weekends. So essentially, it was only open during the hours of the day that most children would be in school. So in essence, there was no time that most children could use the playground. And that's considered a form of discrimination against families with children. So those are a couple of examples that I thought I would share with you of these things that do crop up quite frequently. Okay, next slide, please. So I want to take a step back before talking specifically about the practice of steering. And the reason I do that is because I think when it comes to discriminating against families with children, one question that comes up a lot is, why is this something that is illegal? We understand as a people, as a community, as a nation, why race discrimination is unlawful, why discrimination based on religion and gender is unlawful. What's the deal with families with kids? Why is that the same? And I'll share with you that if you look at the history of the Fair Housing Act, which was amended in 1988 to make familial status a protected class, the reason is because Congress heard testimony and saw evidence that families with children were being excluded from a huge percentage of rental housing in the United States at that time. And that artificially reduces the supply of housing for families with children and increases the cost of housing for families with children. And Congress said, that's not okay. We want to support families in our country. And so that's you know, the in a nutshell, why familial status was added as a protected class. We don't see a ton of cases anymore of excluding families with children based on their familial status from housing. It does still happen sometimes, particularly with mom and pop owners who may not be aware of the law. But it does still crop up now and again. One of the ways it crops up is in steering. Steering is really a form of exclusion, right? Because steering means a housing provider is telling a person or trying to tell a person that certain units are off limits to them because they have kids. It could be because of safety, and I should put safety in air quotes because as you'll see in a second, it doesn't really matter what the motive is. And that's the first example that you have here. And we've seen this time and again with a housing provider saying, we prefer not to rent units upstairs or units with a balcony to tenants with young children. We just don't think it's safe. We want all our families with children to be on the ground floor where they are not as likely to get injured. Another example is making a statement that maybe a family with kids won't be compatible with current residents. Are you sure that you and your daughter will feel comfortable here? It's mostly seniors who live here. It's mostly college students who live here. They party a lot. Are you sure that you and your kid want to live here? That may not look like an outright denial, and it actually need not be an outright denial to violate the Fair Housing Act. Just making a statement that discourages somebody from renting based on their familial status or points out negative features because of familial status. You'll see if you go look at those regulations that I mentioned before that are in the Code of Federal Regulations, 24 CFR, you'll see that making those discouraging statements or pointing out like shortcomings of a dwelling because of familial status, those are considered discriminatory housing practices, even if the housing provider is not saying outright, we won't rent to you in these units. Noise is another reason that we'll talk about more, why a housing provider might attempt to steer somebody to a certain section of the complex. We like all of our families with kids to live here in this section of the complex so they don't disturb the seniors who live in this other area of the complex. That's a form of unlawful steering. The reason that the housing provider might steer somebody to a certain unit or a certain area of a complex, or maybe to a different complex entirely, whether it's, quote, safety or whether it's noise, the reason really doesn't matter. These are discriminatory statements that you need not show intent to discriminate in order for a housing provider to be liable for making those statements and violating the Fair Housing Act. So even as I said earlier, if you have benign intent, even if the housing provider's intent is to protect, in their opinion, children from being harmed, that is considered discrimination. And what the cases have said, what the judges have said, is that, look, it's up to the parents to decide what's best for their family. It's not for landlords to be deciding where it's safe for families with kids to live. Next slide, please. So another issue that does come up from time to time, and I'll say Project Sentinel has really taken a lead in this area, is discriminating against people who have in-home childcares. Back in the early 2000s, Project Sentinel, along with our firm and the Law Foundation of Silicon Valley, successfully argued one of the first cases where an appellate court found that a mortgage lender who refused to lend to a woman because she operated a daycare out of her home and wanted to get a mortgage in a home that she wanted to buy where she intended to operate her daycare. And the mortgage lender said, no, we don't rent to people who, or I'm sorry, we don't loan to people who run in-home daycares. That violates the Fair Employment and Housing Act. And the same would be true if it were a rental, right? Saying I'm not going to rent to you in this apartment complex, or I'm not going to rent this house to you because you operate an in-home childcare. That's considered discrimination under the Fair Employment and Housing Act. It is under the case that I mentioned already, which is called Sizemore versus Master Financial. Under that case, the court said, look, this practice of refusing to lend to somebody who has an in-home daycare discriminates against a person because of their source of income. This woman's source of income was that she operated an in-home daycare, and refusing to lend to her is a form of source of income discrimination, which is specifically prohibited under the Fair Employment and Housing Act. Also, because in-home daycare providers are overwhelmingly likely to be women, and if you look at the statistics, it's 90+% of individuals who operate in-home daycares are women. That is also considered to be excluding people who, from renting or lending to them, who have in-home daycares. That has a disparate impact based on women. Same thing with familial status, refusing to rent or refusing to lend to people who run in-home daycares, who are very likely to have children of their own that they're looking after, and so they are a family with minor children. That has a disparate impact on families with children, so it violates FEHA. When Sizemore, that case was decided under FEHA, there was another law that existed. It is the Health and Safety Code, 1597.40. At the time that Sizemore was decided, that Health and Safety Code prohibited any written instrument, so a lease or another written document, that didn't allow in-home daycares. But the law, and so at the time, that law did not apply to make what happened in the Sizemore case illegal, because the lender didn't have a written lease or a written agreement that said we won't lend to in-home daycares. So actually the court in the Sizemore case said the Health and Safety Code didn't apply there. Now the Health and Safety Code would apply to that situation, because just a couple of years ago, SB 234 was passed, which amended the Health and Safety Code to say that anytime a landlord, a homeowners association, or even a local municipality tries to prohibit in some way a home-based childcare or to discriminate against somebody who operates a home-based childcare. That violates Health and Safety Code 1597.40 and 1597.41. Any attempt to restrict or to deny in-home daycares are void, and a housing provider may not refuse to rent or to sell to someone because they have an in-home childcare. There's been several cases, not under the new Health and Safety Code, it's relatively recent. We have brought a case alleging a violation of 1597.40. That case settled. There wasn't any order from the judge interpreting the new law, the new amendment of 1597.40. So I'm actually not aware of whether there's been any new interpretations of the new law, but there have been a number of cases more recently than Sizemore, where courts have said, in fact, it continues to be a violation of the Fair Employment and Housing Act to exclude people from housing, to refuse to rent to them, to try to evict them because they run in-home childcares. And again, Project Sentinel has really been at the forefront of at least one of those cases that I'm aware of, the Vance versus Bacchus case out of the Northern District of California from 2006. Let me move on from that to the next slide. We've already alluded to this a bit in our previous discussions, but using safety as an excuse for refusing to rent to families with kids, or steering families with kids to certain units or to certain parts of a complex, or to units without balconies, things like that, or using safety as an excuse for rules that are unreasonably restrictive on families with kids, that is not an adequate justification. Some examples that we see crop up frequently still today: refusing to rent apartments with balconies to kids, claiming that they're unsafe. Refusing to rent to kids or to families with kids, saying that, sorry, there's no place to play here. We have too many cars going in and out of the driveway. We're on a busy street. We're on a steep hill. All of those are going to be deemed inadequate justifications for refusing to rent to families with kids, or to restricting them to, let's say, certain areas of a complex. And there's a couple of reasons for that. One is, as we talked about earlier, the cases and the judges have said, look, safety decisions are not for landlords to make, they're for parents. And my understanding is that if you look at insurance analyses, you'll see that the people most likely to get injured in an apartment complex are not kids. They're actually drunk people. And so rules or policies that claim to be for the safety of kids really don't benefit them. And they really don't benefit the landlords either. They don't make anybody safer, and they don't protect anybody from liability. The other thing that I would say is that, as we talked about earlier, rules that end up forcing families with kids out of a complex, and or that just result in their eviction, maybe the housing provider claims they've violated some rule and therefore are being evicted and forced out, that obviously does not benefit a family with kids. By forcing them out of their housing, that does not make them safer. And so these sorts of rules safety is not an adequate justification for these sorts of rules, or for evicting a family with children because they have violated such rules. I'm going to turn it back over to you now, Todd.
Thanks, Liza. Just one thing I'd add on the safety excuses. The way I tend to look at these things, the reason that this sort of safety analysis is so important is that it tends to come up in a situation like Liza's talking about, where there is a facially discriminatory rule, a rule that specifically singles out children or families with children. And in that situation, one of the only ways that a housing provider, a landlord, a property manager can justify that facially discriminatory rule or policy is to show that it actually benefits the people to whom the rule is directed, so namely children and families of children. And as Liza's saying, if it's a situation where the children and the families are going to be evicted or subject to some other sort of penalty, there's no benefit to those to those people, to the children and the families. So it wouldn't pass legal muster, is how I tend to look at this issue. Okay, so Liza very generously left me some of the more tricky issues. So I'll definitely leave some time for her to jump in. Noise, just because it tends to come up when we're talking about familial status and kids in housing. Noise rules that apply to everyone equally are less likely to violate fair housing laws. I say less likely because, as anything, it's going to depend on the circumstances. But in particular, singling out children either directly or in the text of the rule itself. So, for example, children can't play in the West Courtyard, or rules that are enforced more strictly against children or families with children, which is probably the more common situation, may violate the law. It's going to depend on the particular circumstances and the amount of noise. Noise tends to be difficult because it's not something that is easily measurable or quantifiable. It's often very, very subjective, and it's often just by its nature ephemeral. It's not something that you can see in the way that you can see a written rule on the page and compare one noise to the other. Though it does happen sometimes. So for example, one of the situations I've come across would be rules prohibiting quote unquote boisterous behavior being applied to children having a pool party, but not adults having a pool party during the same period of time, where there was music in both situations and approximately the same number of people. That's just one example. I think Liza might have one or two other examples that she might want to share when I'm done with this slide. The other thing I'll say, my impression is noise issues are much more salient, much more common nowadays with COVID lockdown and everyone at home. You have situations where maybe 2, 3, 4 people might be at home in a certain apartment building or a portion of an apartment building, and now you have 20 people at home all the time on top of each other, all living their lives, taking Zoom classes, working from home, etc. We're all on top of each other to a large extent. We're all making noise that each other can hear, and we're all stressed out to various degrees, and that those circumstances lead to more conflicts. But what I'd say would be, again, if it's a situation where families with children are being targeted, kid noise, kids walking around, that's what's tending to trigger notices of violation issued by on-site managers or landlords. And it's not situations where adults, a similar number of adults in a unit, who may also be practicing guitar or ukulele or whatever people are doing to try and cope with these last few months of COVID lockdown. Those sorts of situations with adult noise isn't triggering the same kind of response. That's going to be a situation where families with children are being treated differently, and it's going to be more likely that the fair housing laws have been violated. But before I turn it over to the next slide, I'm going to just give Liza an opportunity to add anything, if Liza, if you have anything else to say.
Yeah, I mean, I think you've rightly pointed out that noise is a kind of difficult issue to address. I would say a couple of things that have cropped up in my practice that I find helpful. Um, One is, as you pointed out, Todd, that sometimes these types of noise complaints or noise rules are not enforced even-handedly. I had a case a number of years ago, which was a kind of traditional California style apartment building that had a courtyard in the middle. And residents did all kinds of things in the courtyard. There was some gardening that was going on in little boxes and things like that. And our clients, who happened to be the only family with kids who lived in the building, this was a relatively small building. I think it had 10 units or something. They had adopted a child, and as he became a toddler, he had a toy car. It was one of those little things he could push around, not a little car, but a more sort of ride-on type of thing that he could push around or ride around in the little courtyard. And apparently the sound of the car in the courtyard really annoyed the manager. Nobody else complained, but the manager really didn't like it. And he gave them a number of different notices and yelled at them out of his window a number of times and really tried to get them to move out because of the noise that their toddler was creating. Well, it turned out that this manager was a pretty avid motorcycle rider. And so many mornings, particularly on the weekends, you could stand in the courtyard and hear him working on his Harley and revving it. Decibels of that much, much louder, right, than the toy car in the courtyard. But the manager had no issue with, his own revving of his Harley in the courtyard. That's an example of how the rules, and I don't even think there were any written rules in this particular scenario, it was just notices about excessive noise that were being given to our clients and verbal, scolding to our clients, obviously being applied differently to the family with kids than to other residents, including the manager himself. So that could be a form and is in fact a form of discrimination based on familial status. And the other thing that I would say is that, look, just in general, life is noisy. I don't know if you can hear, but I happen to live very close to a small airport, not even SFO, but just a small airport. And there are loud planes outside my window as I'm on the Zoom. And all the time as I'm on calls or on Zoom during shelter in place, I'm hearing loud airplane noise. I can't control that. Nor can a person living in an apartment or some other communal multifamily housing really control the noise that other people are making within reason. During the shelter in place, people have been a little more on edge. People have been working from home, but the reality is that we really just we can't control everything, and that's just not necessarily something that's written in the fair housing laws, but something I would ask people to be understanding about.
Thanks, Liza. Okay, so this last specific issue we're going to touch on is the issue of numerical occupancy restrictions in rental housing in particular. And these would be rules or policies limiting the total number of people that can live in a particular apartment or condo or townhouse or whatever the rental housing is. The best policy is going to be one that's based on square footage that's consistent with the Uniform Building Code, which tends to lead to a fairly high upper limit of occupancy. I have heard of folk understandings or sort of passed down understandings among different housing providers that there's supposedly some local county restriction of various kind that would prohibit renting a particular apartment with a certain number of bedrooms to a household with over a certain amount. Whenever I've looked into that and pressed it, there often isn't any particular restriction. The only restriction that really tends to apply across the board would be the restriction in the Uniform Building Code, which is based on square footage and a living area, and tends to be fairly generous in terms of the total number of people that may be permitted to live in a particular dwelling based on those code requirements. As a sort of rule of thumb, there is what some people call the 2+1 rule. So the guideline is 2 people per bedroom plus 1 person. So the idea would be if it's a 1-bedroom apartment, 3 people would be the target occupancy number. If it's a studio, it would be 2 people. You get the idea. Anything more restrictive than that sort of rule of thumb tends to draw attention because it's unusual and may be more likely to violate fair housing laws, simply because restricting the total number of people who can live in a unit, by definition, tends to limit families with children that tend to be larger from renting housing. But when this issue of numerical occupancy limits come up, the other thing is, as we've been talking about so far in the presentation, you look at what the actual rules are, and a numerical occupancy limit, generally speaking, isn't going to specifically target children. If it does, it's a much easier case. That occupancy limit is going to violate the state and federal fair housing laws. But even if it's just an across-the-board limitation as to number of people, you'd want to look at what's behind this rule or policy or guideline that's being applied to this particular housing. Are there other suggestions, indications, actual concrete examples of discrimination against families with children along the kinds that we've been talking about? Are there other facially discriminatory rules? Is there some sort of pattern by the housing provider or at the complex as far as treating families with children differently? How many families with children are actually living in the complex or in the housing? Is there some indication that families with children are being excluded from the housing? And then related to that, the question that we would tend to ask would be, are these numerical occupancy restrictions actually being equally enforced? Are there exceptions being made to households of single adults, like multiple roommate situations? You have 2-bedroom apartments where there are 6 roommates, all adults who are living in those units. But when a family of 5 wants to rent a comparably sized apartment in the complex, they're denied, and this numerical occupancy limit is cited as the reason. And then the last thing I'll say is it's not something that we've gone into great detail in this presentation, but one of the other forms of unlawful discrimination is disparate impact. It's a way of establishing that a particular act or housing practice is unlawful under the state or federal laws. So far, we've mainly been talking about what's called disparate treatment, that is deliberate intentional discrimination for the most part. No, I'm not going to rent to you because you have a 5-year-old child, and I don't feel comfortable renting to someone with a minor in this particular apartment or complex. It's singling someone out specifically because of a protected classification, in this case, familial status. But you can also have a situation where there's no intent at all, that you can have a facially neutral policy or rule that limits the ability of in this case, families with children from renting housing, that if it has a broad enough effect and it's possible to establish on the front end, is exclusionary, and the housing provider or management company is not able sufficiently to justify this restriction, that rule or policy can be held to violate the state or federal laws, even if there is no specific intent proven or particular intent proven to exclude families with children specifically. Even if it's just a neutral rule, it's possible that that rule could be the basis for Fair Housing Act liability or FEHA liability, even without intent. The more restrictive the rule is, the more it tends to exclude, the more likely it is that that sort of rule or numerical occupancy restriction will be held to be unlawful on one of these disparate impact theories. I'll leave that there, and I'll let Liza add anything that she might want to. Thanks, Liza.
Yeah, thanks, Todd. I would just add a couple things. Numerical occupancy restrictions are an example of one of those facially neutral policies that you mentioned, Todd, that may be subject to a disparate impact analysis. In other words, if the occupancy restriction is just, we only allow 2 people per bedroom. So if it's a 1-bedroom apartment, we're only letting 2 people rent here. Or if it's a 2-bedroom apartment, we're only letting 4 people rent here. That's facially neutral, right? Assuming that you don't have a rule that says if it's a family with kids, it's this many people, and if it's all adults, it's that many people. It is facially neutral. And so if it, in order to argue that it violates the Fair Housing Act, which we've done in many cases, you have to apply a disparate impact analysis. That rule, that numerical occupancy restriction, has a disparate impact on families with children because they tend to be households with larger numbers of people. And you typically have to look at statistics to make out that case. And then you have to look at the justifications that the housing provider has set forth for why they have this numerical occupancy restriction to determine whether they're sufficient. And disparate impact analysis is an evolving area of the law. There's been a lot of litigation around exactly what the plaintiffs have to show or what the defendants have to show to rebut the plaintiff's case in disparate impact analysis. And so it's really beyond the scope of what we can talk about here. But I just want to leave you with the knowledge that numerical occupancy restrictions may violate the law because they have a disparate impact on families with kids. And in the same way that charging extra rent, for example, or charging extra security deposit based on the number of people in the household, that too may have a disparate impact on families with kids. And so in most instances, it is not legal to charge a surcharge or to charge an amount of rent based on the number of people in the household, or to charge a security deposit based on the number of people in the household. I had a case a number of years ago where we were able to get stricken a minimum income requirement that went up depending on how many people were in the household. The housing provider in that case said, well, if you're a single person, you have to earn 3 times the rent to live here. If you're a couple, you have to earn 4 times the rent to live here. If there's 3 of you, you have to earn 5 times the rent to live here. And it went up and up and up depending on how many people were in the household. That has a disparate impact based on families with children and is unlawful. And we brought a case to enforce the fair housing laws in that case. One other thing just to mention on this slide, one other piece of evidence that we frequently look at or look for when we are evaluating a case based on numerical occupancy restrictions is whether there is a history at this particular complex or mobile home park of it being adults only. So, for example, before the law was amended to add familial status as a protected class, or before the law changed here in California, which happened even earlier than on the federal side, before the law changed, there were plenty of housing providers and mobile home parks that were adults only, or that had other age restrictions. You have to be at least 40, or you have to be, at least 18 to live here. So if there is a history of that sort of restriction, that may be other indicia, other evidence of a past history of familial status discrimination that a housing provider is now trying to perpetuate in other ways. They're not saying they're adults only anymore, but they're finding other ways to exclude or limit the number of families with children in their housing. And that could be important evidence in doing one of these types of cases.
Thanks, Liza. Okay, so just a few concluding thoughts. I'll say a couple of things, and then Liza, I'll turn it back over to you. Again, thank you all for joining the presentation. Just a few concluding thoughts, and then I'll turn it back over to Nicole and Daniel for a question and answer session. First thing I'll say is, unfortunately, familial status discrimination in housing, it's still happening. It's been illegal for decades, but it's probably one of the most common types of housing discrimination that you tend to see. Certainly, I think one of the more common that tend actually to be litigated. And speaking of litigation, the stakes in litigation are high. There are attorney's fees that are recoverable to successful plaintiffs in these cases. The costs associated with losing someone, losing a home, being required to move, the disruptions, both emotional and economic, that are associated with that kind of disruption based on illegal discrimination are also large. The recoveries and the amount of money that a defendant tends to pay in these cases tends to be quite large. The thing that surprises me doing this type of work is just how often defendants refuse to try and work things out, or even to recognize that there was some sort of compliance problem, and instead they'll drag things out, and it just makes things worse for them for no good reason. I'm not really sure why that is. Generally, you'd think you'd recognize working in this area that mistakes get made, things are said that shouldn't be said, people are treated unfairly, and you try and deal with it, but often that's not the case. And hundreds of thousands of dollars tend to get expended on both sides, and the landlord ends up having to pay for that. But thank you again, and I will turn it over to Liza for any of her concluding thoughts.
Sure, I'll just share a couple things before we go into the question and answer session. One is that the protection for families with children under the Fair Housing Act is in some ways slightly different than the protections based on race. And let me tell you how. It is unlawful to discriminate based on race. That means if a housing provider or a lender prefers or disprefers somebody because they are Black, it violates the law. It also means that if a housing provider or lender or real estate person discriminates against somebody because they are white, it violates the law. So I hate the term reverse discrimination, but colloquially, that's what some people might call it. That too is illegal when it comes to race. It's not true when it comes to familial status, at least not under federal law. If a person says, hey, they preferred the family with kids and rented to the family with kids instead of me, and I'm a single person, or I'm in a couple, but we don't have kids, whatever, they're actually not protected from discrimination. It's not a protected class to be somebody without kids when it comes to the housing laws. The other thing I would say is there are some exceptions here. So if a housing provider is genuinely providing housing for older persons, people 60 and up generally, and there's a number of regulations that apply to that. So a mobile home park, an apartment complex can't just say, hey, we're going to be housing for older persons, and tomorrow everybody who's under a certain age has to move out. Can't do that. But for those that are legitimately and have gone through the proper channels and the proper regulations to become housing for older persons, they're actually allowed to exclude families with kids if they want to. They don't have to, but they can. So that is an exception that we really haven't talked about, and it applies to very, very few housing providers. Then the last point I want to share with you before we move into the Q&A, and maybe some of you had questions about this, is we haven't really talked a lot about how these laws get enforced. Todd has pointed out appropriately that the stakes are high when it comes to litigation. I don't know if any of you out in the audience are housing providers or are attorneys for housing providers. I don't really want to find myself on the other side of a lawsuit from you. These are costly cases to litigate, both from an attorney's fees standpoint and damages. There are other ways to resolve them. Many of these cases are resolved informally. So Project Sentinel, for example, takes complaints both from housing providers and from tenants and applicants, and frequently they can work through these issues informally just by helping with communications back and forth between housing providers and applicants or tenants and try and resolve things informally. The other way that sometimes these cases get resolved is by a complaint to HUD or the Department of Fair Employment and Housing. As I mentioned, you can go straight to court as a complainant if you want to do that, but you can also, if you choose, file an administrative complaint with HUD or the State Department of Fair Employment and Housing. They will do an investigation, and if they agree that you have been the victim of familial status discrimination, they will bring a case on your behalf. That's just some of the enforcement options in a nutshell. And if you do end up in litigation or in an administrative action, again, as Todd said, the stakes are high. And so it's really better to try and nip these kind of problems in the bud rather than find yourself in that situation. So thank you.
Thank you, Liza and Todd, for giving this presentation. It was definitely very helpful. So we're going to move into the question and answer portion. But first, if you guys would please do us the favor of polling our presentation. You should be able to find the poll at the bottom of your screen at some point, mainly for recording purposes, and also so this way it will help us provide better or just more information throughout our presentations in the future. So yeah, so we're gonna go ahead and start. We do have quite a few questions and a couple of hands up. So let's get started. Okay, so I'm gonna start off with the chat. Let's see. Okay, so Roxana Mendoza asked, can a landlord increase the rent amount because a tenant just had a newborn baby?
I'll tackle that because it's actually something I mentioned there toward the end. The general answer is no. Surcharges when you have additional family members are generally not allowed. And the reason is that they have a disparate, it could be intent-based, right? It could be a disparate treatment claim, as Todd pointed out, where you're saying because you had a baby, you now have to pay additional rent. That could be considered facially discriminatory. It could also be that the landlord has a policy of charging more when you have additional household members. When you have, a certain number, you pay this much. When you have that number plus one, you pay more. That it could be analyzed with a disparate impact analysis that has a disproportionate effect on families with children. And so typically that's not allowed. I will say though, there is an argument that can be made that if the extra amount the tenant is being asked to pay is closely related to the extra cost that the landlord has to pay for additional people, For example, let's say an additional person in the household means there's going to be an extra $20 a month in water usage, and the landlord pays for the water usage, then arguably the landlord can pass on that charge to the tenants. Typically, it's not going to be reasonable unless it's at least 10% or at most 10% additional rent, right? So it has to be really closely tied to extra costs that the landlord actually pays. To say that additional people, like a new baby, would cause more wear and tear, and that's why the landlord is increasing the rent, probably not going to be an adequate justification to increase the rent or add a surcharge.
Yeah, I just echo what Liza's saying, especially if you're talking about a newborn infant. The direct economic effects or even wear and tear effects of such a small child are going to be very small. So I would be surprised if any kind of sizable surcharge would be permitted under the fair housing laws. And for that reason, it's probably not worth it in most situations.
Todd, do you want to stop sharing the PowerPoint now? Thanks.
Thank you for answering that question. All right, second one is from Adrian Ocampo. For the supervision rules, does this apply to nonprofits that provide services at transitional housing shelters?
Yes, most likely it does, particularly FEHA. The UNRWA Act has some limitations in terms of like private clubs, I think, may not necessarily be covered under FEHA, but yeah, transitional housing is typically going to be considered a covered dwelling or a covered housing accommodation. And so they would be subject to the same laws as, you know, a commercial apartment complex or something like that.
Yeah, I'm in line with what Liza's saying, of course. It's always good to agree with Liza. The definition of covered dwelling under the federal law and the state laws are very broad. So, you know, even a mobile home plot of land with nothing built on it is going to be subject to the requirements of the housing discrimination laws.
Thank you. All right, moving on, Daisy Manriquez. She has a couple of questions. So the first one is, with the rule of the playground and not being able to use it between 3 p.m. and dark, what would you do as a parent in this case? How would you bring up this discriminatory action to the apartment complex office?
Liza, do you like to?
No, go ahead, Todd.
Oh, great. So, I mean, I would really echo what Liza said earlier. There are fair housing organizations like Project Sentinel that are here existing to help people try and resolve these sorts of issues when they come up. My first call would probably be to Project Sentinel. When you're approaching Project Sentinel or anyone else that you're trying to get help from, what I'd recommend in terms of practicalities would be to have a copy of anything in writing that you might have from the housing provider, an email or a copy of the notice or the policy, just so you can answer questions about it initially. But if it is a policy that is that specific, I would definitely approach a fair housing organization like Project Sentinel and help and give assistance in potentially investigating the situation and also potentially reaching out to the landlord about changing the policy.
I have nothing to add.
Thank you. All right, the second question from Daisy is, what about housing that only take families if they have another agency helping with rent because they know they are low income and do not meet their income requirement? Is this considered discrimination that they were willing to accept them to live in one of their units if they got assistance in rent and signed their form for a long-term rent assistance from an agency? My apologies.
I'm not sure I fully understand what she's asking, so I'm not sure I can answer that question. Again, as Todd said at the beginning, there may be some specific issues that folks are having that are outside of the scope of what we can cover. My suggestion would be that if you have a really specific question like that you go to Project Sentinel, where you can actually speak one-on-one with the counselors there. And I imagine you all are doing most of these things by phone or by email right now. So you can contact them and talk through whatever specific question or specific problems you're facing right now.
I'm going to leave our contact information in the chat box, so it'll be helpful for most of the questions. All right, okay. There's an email contact, and then I will pull up the phone number in just a moment. Okay, where did we go? So the third question from Daisy was, so then how did those tenants handle the situation of the little toddler with the bike and the loud motorbike manager? She also said, I feel like we are getting told lots of great examples of situations, but what are the solutions of these examples? How were they handled? How would you recommend the tenants to handle these tough situations? I feel like we kind of somewhat went over that a little bit.
Yeah, what the tenant with the toddler did was they complained to Project Sentinel. That was actually a case here locally. I do cases all over the place, but that was actually a case in San Francisco. And that tenant complained to the local fair housing organization. They complained to Project Sentinel. And these fair housing agencies exist all over the country. And I imagine that most of you on the video are within Project Sentinel's service area. And so what they did was they made a complaint to Project Sentinel. Project Sentinel conducted an investigation. They looked at the notices this family was getting. They interviewed this family, and they helped them find counsel and file a complaint to enforce their rights under the law. That's how that was resolved. That's not always, doesn't always require litigation. As I said, frequently Project Sentinel can intervene on behalf of the residents or the applicants who are facing problems and resolve it without litigation. But when that fails, a complaint to the administrative agency or filing a civil action with counsel, that's how these cases get resolved.
Thank you. All right, another question from Diana Cervantes. Can landlords increase rent when they haven't altered damages to the property that tenants have asked landlords to fix? AC unit, water issues, damage areas in home. Not sure if this is a familial status, but feel free if you're wanting to.
Yeah, this sounds like more of a question for, as Liza was saying, a specific situation that perhaps one of Project Sentinel's landlord-tenant counselors might be able to deal with.
Of course. And again, please feel free to send us any referrals to that email, and I will provide the number in just a few minutes, sorry. Alrighty, the next one, is there some type of document that tenants can provide to a landlord to prove their rights?
Well, I'll jump in first, and then we we can. I'll take the first shot. I would say rather than trying to do that yourself, what I'd like to see would be a tenant again, and I'm going to say the same thing we've been saying before. Go to Project Sentinel because they're the experts, and they'll often be able to provide the specific documentation that you might want to inform the landlord of, or even better, often in certain situations, so there's a clear-cut violation of law. Project Sentinel can directly contact the landlord or property manager and explain what the requirements are. Often I've tended to see, in terms of trying to resolve something, a housing provider will often be much more receptive to receiving a contact from a fair housing organization like Project Sentinel than they might be from a current tenant or an applicant.
Their services are free. So, you have no reason, honestly, not to go to a fair housing agency to ask your question or to have them help you try and intervene with the landlord. I will say there are a number of brochures available online regarding fair housing rights. If you go to the website for HUD or to the website for the Department of Fair Employment and Housing, they have a number of publications as well as videos that you can look at yourself, and that you can also give to a manager or a landlord. I think it probably works better to go through Project Sentinel or to go through another fair housing agency to have them help you do that. But those brochures are out there, and those sort of frequently asked questions and info sheets and things like that are available on the websites for HUD and the Department of Fair Employment and Housing on all sorts of topics.
I guess just the one thing I'd add, and it would depend on the particular circumstances, but I worked with Project Sentinel on a case like this. If you think this is a situation where you are actively being discriminated against, if the property manager is enforcing rules, for example, against you and your family unequally, specifically because you have a child, and that this is a problem throughout the complex, you really might want to contact Project Sentinel also to allow Project Sentinel the opportunity to do some kind of investigation beforehand, without tipping off say the on-site manager, for example, that someone's looking into this. Because once you say fair housing, civil rights, their antenna is going to go up, and they may be less forthcoming in terms of describing what their actual reasons are. Discrimination, most of it, more than half the case, happens in the defendant's head. So if the defendant is warned, they may not provide the kind of information about what they're actually doing that would allow you to make the case more directly and successfully.
Thank you. Okay, moving on to the next question. Katie J. Cox, she asked if the slides could be sent to the email if they were going to be available. Would you give us permission to send them out, or it's up to you?
Yeah, I don't know about you, Todd. My only request is that if the slides are shared, they're shared in PDF instead of in PowerPoint. I'm happy to share them myself. Also, if you are a service provider or a fair housing counselor, I'm also happy to speak with you offline. You can email me. My email address is available on the Brandcart and Brandcart website. If you are an individual housing provider or an individual tenant or applicant with a specific question about fair housing, I would direct you to go to Project Sentinel, though. I typically don't accept cases or give legal advice until someone has gone through a fair housing agency. So if that's you, I would say don't contact me directly. You're not going to be happy with my answer, which is go to Project Sentinel first. But if you're a legal services attorney or any kind of attorney, and you have a question, you want to talk through a case, or your social service provider or a fair housing counselor, I'm happy to just chat with you and answer questions by email or over the phone. So feel free to reach out.
Kevin Park said, scary thoughts. As a father, I could easily see myself thinking about the questions around the child's safety independently. How do owners protect against liability when issues do arise? For example, if a child gets injured at a pool or from a second floor balcony.
Go ahead, Liza.
I would just say I have two responses to that. One is insurance. That's why people have insurance, is in case someone gets injured on the property, whether it's an adult or a kid. The other thing I would say is that landlords need to make their properties safe, period. So if you as a parent, let's say you're a housing provider who also happens to be a parent, you look around and you see there are hazards. You have an obligation to fix them, right? So if the bars on the balcony are so wide that a kid could fit through them, by all means, fix it. Put up some sort of protective barrier, plexiglass or whatever the case may be. Put a fence around your pool, right? So there are a number of things that housing providers are obligated to do in order to make their property safer. Having rules regarding what kids can and can't do on the property is not one of those things.
Yeah, I agree with everything that Liza said. I don't really have much else to add, except that, we tend to, or at least I tend to see these sorts of safety issues raised, curiously, only outside of units, where, and a lot of the hazards, climbing, water and fire, so forth, those also exist within the apartments. There are bathtubs and stoves and things for the kids to climb on. But for some reason, when I hear safety justifications, it's only the outdoor safety justifications that get raised. Kind of funny how that is. It's almost like they don't want children outside.
Thank you. Okay. Katie J. Cox also asked, so when it comes to the noise complaints, essentially, would noise just have to follow the city laws at that point? Or at which point would it be discriminatory, essentially? I know this is a question that we kind of all have had in the past, but yeah.
I mean, it's really difficult. It's always going to be, as Liza was saying, as I was trying to say, it's going to be a situation of just balancing, your right to quiet, your right to live in your home with your family or on your own. It's not going to be some sort of cut and dried across the board rule that we can point to. What we can say is, in particular, if rules are being applied more strictly towards children and the types of noise that children make, that is most likely going to violate the fair housing laws.
Thank you. Okay, an anonymous attendee had asked, are all of these rules that apply to owners of their own home? I'm a little confused on that question.
Well, that we didn't really talk too much about what property is covered by the fair housing laws, but I guess it depends on what the question is, right? If you are an owner of a single family home in which you live in, then these rules generally don't apply to you. If you rent out housing to somebody else, let's say you have a second property or you have a duplex or something like that, and you rent out property to somebody else, then yeah, these rules do apply to you, even in a single family home, if you rent out that home to somebody else.
Agree. Okay. Another anonymous attendee put that they missed the details. So students only, seniors only are or are not allowed, or in shared housing, single occupancy only allowed.
Students only is not going to be allowed in most housing. I mean, obviously a dorm is slightly different, but other forms of housing that are restricted to students only are that would be considered a form of discrimination. Adults only is also not allowed. However, there are certain allowances for seniors, for housing for older persons. It really is outside of the scope of our presentation, and the regulations governing housing for older persons are more extensive than we can go into on this call. But there are some exceptions that allow housing that is exclusively for older persons. And there, if they genuinely are housing for older persons and they meet all of the requirements, of which there are numerous requirements, then they may exclude people based on age, and they may exclude families with kids. But it's a very narrow exception. It's very narrow. It's not going to apply to the vast majority of housing where we see these sorts of issues crop up.
Yeah, I agree with that. I'd say in general in California, because our fair housing laws are so much stronger, the situations where housing will not be subject to one or more of the anti-discrimination requirements are pretty unusual. And I'll definitely echo what Liza says about the housing for older persons exception. Even if the housing were designated in that way, in some situations where the actual occupancy of the building or complex isn't of a certain age profile, the exception wouldn't apply, for example. But as Liza's saying, it's beyond the scope of this particular presentation.
Thank you. Marta asked, do these rules apply for mobile home parks as well? Because many mobile home parks have age restrictions.
Yes, it does. These do apply to mobile home parks. As Liza was saying, mobile home parks may be designated for seniors only if the designation is done properly, and it actually is seniors who are living there, subject to the various restrictions that are a little complicated and beyond the scope of this presentation. Yes, familial status discrimination laws do apply to mobile home parks.
Thank you. Most of these questions that I'm receiving are mainly to provide more information about how to file a complaint. That's something that, again, you can always come to Project Sentinel for. Daniel, can you please do me the favor of writing in the chat box the number of how to contact us? Because I can't seem to find it. And I don't know it off the top of my head at this time. Let me see if there's any more. There's one specifically about the pandemic. During the pandemic, can a landlord raise someone's rent? Is there a restriction on how much someone can raise the rent by when it's not a pandemic year? Also for occupancy reasons.
Again, that really exceeds what we're the topic that we're talking about. If you have questions about rent increases during COVID, those are questions that you should take up directly with a Project Sentinel counselor. Todd and I work in the area of housing discrimination, which is not the same as sort of general landlord-tenant rules and general landlord-tenant laws. So what you want to do is you want to contact Project Sentinel and ask to speak with a landlord-tenant counselor, and they can give you information about restrictions on evictions or rent increases or things like that, if there are any during COVID. It may also depend on where you live, because different cities have different rent control laws. And so you need to speak one-on-one with a landlord-tenant counselor about that.
Yeah, I definitely agree. Project Sentinel should be your first call in most situations, or whatever the fair housing or landlord tenant counseling organization is in your area. I would say though that just to point out that there are various restrictions that apply potentially where there's going to be some rent increases, or a situation in the past where a landlord's attempted to increase rent, especially recently, in terms of restrictions that are specific to price gouging and the COVID emergency declarations and fire declarations. And then also there's a recent state law that went into effect capping rent increases statewide, in addition to the local rent control laws that Liza mentioned. But Project Sentinel or some other local housing counseling organization would be the place to call for that information.
Thank you. And I just put in the chat our number. Thank you, Daniel, again for helping me out with that because I could not find it. Lastly, I'm gonna allow to speak Jenny Bader. She has had her hand up, so I'm just gonna see if she has a question. Hi, Jenny. You can unmute yourself if you'd like. No. Alrighty.
I did see one other question in the chat.
Oh yeah, let me put
Natalie asked, how long typically does the investigation process take?
Oh yes.
Yeah, and I would say it depends on how long, it depends on who you're asking about. So there's a number of different people or agencies that might do an investigation in a fair housing case. Project Sentinel does investigations. So if you were to bring a complaint to them, they may be able to investigate it. And how long that would take would probably depend on what kind of situation it was, because there's a number of different tools they have that they can use to investigate, depending on what kind of case it is. So it might, the length of the investigation might depend on, are there any vacancies at the property right now? Does Project Sentinel need to do a survey of all residents in order to determine whether there's other families with kids who might be being treated improperly and illegally? So there's a number of factors which could go into determining the length of the investigation. If you make a complaint to the Department of Fair Employment and Housing, or HUD, the length of their investigations also really varies. It could be a matter of months. It could be a matter of years. I have had cases pending at HUD for upwards of 2 years before they make a decision about whether they think, in fact, my client has been the victim of discrimination. And the same is true with DFVH. I think most of the time it happens within a year, but not always.
Yeah, I agree with all that. And then I'd say on top of that, litigation tends to be longer, but not necessarily. Sometimes things settle quickly, but usually longer.
One of the last questions just right now is like a simple scenario. An anonymous attendee said that my family was evicted March 11th, 2019. I believe we were discriminated on many levels. I wish I had time to tell you my story. Anyway, we are looking for housing now, but afraid that the eviction will prevent us from finding a home. Is there a way around it? This was also during shelter in place. We went through a lot, but thankfully to God and resources like you, we're resilient and have hope.
Yeah, that just sounds like a really difficult situation. I'm not going to be able to really say anything one way or the other about it, other than to say to contact Project Sentinel, get your documentation together, and see what they can tell you.
Yeah, I would just share my sympathy. What a tough situation to be in, especially during a pandemic. I'm sorry that happened to your family and unfortunately to others as well, I'm sure. But it's not something that we can give you any advice about during this webinar. That's not, unfortunately, it's just you need one-on-one advice. And so you should contact Project Sentinel and ask to speak with a counselor to give you more information about your rights and what rights you may have when you're seeking housing in the future, as well as what happened when you were evicted.
Thank you. I would say the same thing. Again, just contact us, leave your name, number through the email. You can also call us and we will get to you as soon as we can. Daniel, do you have anything else to share at this time?
No, I don't have anything specific.
Okay.
Yeah.
Well, again, thank you for all of your questions. Thank you again, Todd and Liza, for being here with us today. Definitely helped us out a lot. And for giving the wonderful presentation as well. Those of you who had left me contact information, I will reach out and see, again, as a referral process to file a complaint, or also just to listen to your stories and to see what we can potentially do for you. But yeah. Thank you again for joining us. And again, if you haven't finished the poll, please do so right before exiting. And may you all have a wonderful day, wonderful Friday. Yes. Thank you again, everyone.
Thank you.
Thank you.
Thank you. Bye.